You're trying to collect a business debt in Missouri. The client hasn't paid. This is a common, frustrating problem. That federal law you fear in debt collection? The FDCPA? For your business-to-business debts, it probably doesn't apply. The real risk is a state law, the Missouri Merchandising Practices Act. It covers B2B collections and forbids unfair practices. To make things riskier, Missouri doesn't license commercial debt collectors. The responsibility for lawful collection is entirely on you. Here, we'll break down Missouri's B2B debt laws, from hidden legal traps to the steps you must take to collect what you are owed. Let's be clear. There is no single federal law that directly regulates how you collect a business-to-business debt. Before taking any action, you must know your deadline. In Missouri, the time you have to sue is set by the statute of limitations. With a written contract, you have a generous 10 years to file a lawsuit. This gives you a massive advantage, but only if your paperwork is in order. However, for oral agreements or ongoing open accounts, that window is cut in half. You only have 5 years. Many lose their rights by waiting too long. The lesson is straightforward. A handshake deal gives you half the time to collect as a signed document. Your paperwork directly impacts your legal rights, so you're within the time limit. But what if the debtor is a corporation with no assets? Are the owners protected? Not always. This is where we find a serious concept in Missouri law: piercing the corporate veil. It lets creditors go after an owner's personal assets. This isn't easy, but it happens. So what specific actions cause a business owner to lose this protection and become personally liable? A Missouri court uses a 3-part test. First, they look for complete domination, where the owner treats the company like a personal puppet. Second, the court must find this control was used for an improper purpose, like fraud, or intentionally avoiding a debt you never planned to pay. Finally, that improper act must be the direct cause of the financial loss you suffered. Their misuse of the company structure is why you were not paid. That 3-part test sounds theoretical. So let's look at the specific, real-world mistakes that can satisfy it. Number 1, commingling funds. This means using the business account for personal expenses. It's the clearest sign the corporate separation isn't respected. Number 2, ignoring corporate formalities. This is failing to hold annual meetings or keep minutes. These are legal requirements, not suggestions. So, what actions lead to personal liability? The answer is clear: treating the business like a personal bank and ignoring the basic rules. In some cases, Missouri courts even allow inside veil piercing, where one owner can sue another personally for misusing the company. Now that you understand the high stakes involved, let's talk numbers. If you win a judgment, what can you actually collect? First, interest. If your contract is silent, Missouri law sets the rate at 9% per year. However, you can contractually agree to a higher rate. Here's a key detail for B2B collections. In Missouri, corporations generally cannot use usury, an unlawfully high interest rate, as a defense. After a lawsuit, you gain powerful tools. You can garnish an owner's wages up to 25% of their disposable income, or place liens on property. And a Missouri judgment is a long-term weapon. It is enforceable for 10 years, and it can be renewed, giving you a very long time to collect. With all these rules and remedies, how do you form a compliant and effective collection strategy? It comes down to connecting the dots. Recall the 10-year versus 5-year time limit? Your record keeping unlocks that longer period. A written contract is your best collection tool. We also know the federal FDCPA doesn't apply, but the Missouri MMPA's ban on unfair practices does. So how do you define what's unfair? The most powerful insight is this: treat the FDCPA as a gold standard. By following its principles, you build a strong defense against MMPA claims. So the winning strategy is twofold: solid documentation to protect your rights, and an ethical collection process to shield you from liability. First, your primary legal concern is Missouri's Merchandising Practices Act, not the FDCPA. Avoid any action that could be seen as unfair. Second, personal liability is a real threat. Maintain a strict separation between business and personal finances to protect your own assets. And third, your documentation is everything. A written contract defines your rights, sets the interest rate, and doubles your time to collect. Missouri's laws require diligence. Protect your business from the moment you sign a contract. Review your agreements and procedures today.